The room was already tense, but nobody expected what was about to happen next. Pam Bondi walked into the House Judiciary Committee hearing with a 37-page prepared statement. Her legal team had rehearsed answers for days. They had prepared for political attacks, for legal scrutiny. They had not prepared for what came next. What followed became one of the most explosive congressional hearings in recent memory. Confrontations so precise and so damaging that observers are still talking about every single moment. This is a breakdown of the wildest exchanges, and they get more serious as we go. The first confrontation began quietly. Ted Lieu placed a single document on the desk, not a speech, a bank record. He looked directly at Bondi. "Attorney General," he said calmly, "explain this bank receipt. $847,000 wired at 11:47 p.m. on February 3rd. The document was already on the screen behind him. Every camera shifted toward it. Her name was on the record. "You are sitting here under oath," he continued, telling this committee, "you have no knowledge of any Epstein-related payments." The chamber went completely silent. Lieu was not a typical politician. Before Congress, he had served as a military lawyer in the Air Force Judge Advocate General's Corps. He built cases document by document. That morning, he brought the same method into the room. He introduced a second document, a privilege log listing 47 entries. Each carried the same label, Code D. Lieu held the page toward the cameras. "Code D does not exist in standard federal privilege classification," he said. He turned toward Bondi. "What is Code D?" No answer came. He entered the document into the congressional record, then placed a third page on the desk. A tweet Bondi had written 2 years earlier. "Any official who uses privilege designations to obstruct a federal investigation should face immediate criminal referral." He read it aloud. "Put the page down. No commentary needed." Then came the financial analysis. The $847,000 had not arrived in one transfer. It had been divided into 18 smaller transactions over 11 months. Each kept carefully below $10,000. Under federal banking law, transactions above $10,000 must be reported. Breaking large sums into smaller amounts to avoid that threshold is called structuring. Lieu leaned toward the microphone. 18 payments. Total amount $847,000. Attorney General Bondi, who structured this account, her attorney objected immediately. The chairman overruled him. Bondi remained silent. Then Thomas Massie leaned forward. "I have a simple question," he said. "Not about legal theory, about math. 18 payments below $10,000 each. Together, they total exactly $847,000. He paused. "In your experience as a prosecutor, when financial activity is structured that precisely, what does that suggest about intent?" Bondi's attorney whispered something. After a long moment, she answered, "I cannot recall." Massie wrote something in his notebook. He did not ask another question. But that wasn't the end of his role that morning. 2 days earlier, Massie had been inside a secure reading room at the DOJ reviewing unredacted Epstein files. The same files Congress had ordered released. The same files Bondi's department had released with thousands of redactions that didn't make sense. He had found something. One specific redaction. One name. He lifted a printed document. An FBI file listing individuals connected to the Epstein investigation. Inside it, the Bureau had flagged a name as a potential co-conspirator. When Bondi's department released it publicly, that name was blacked out. Then Massie said the name on the record, Les Wexner, billionaire, former CEO of Victoria's Secret, the man who once granted Jeffrey Epstein power of attorney over his entire financial empire. Bondi tried to recover. She said Wexner's name appeared more than 4,000 times in documents already released. "I know it appears 4,000 times, Massie said, but in this specific document, the one where the FBI identifies him as a potential co-conspirator, his name is redacted. Why?" Bondi looked toward her staff. "If there was an error in that redaction," she said, "we will review it and correct it." Massie leaned forward. "Attorney General Bondi, I'm glad you said that, because about 40 minutes ago, after I raised this issue publicly, your department quietly unredacted Wexner's name in that document." He held up another page. "I caught you hiding a potential co-conspirator's name. And within 40 minutes of being caught, you fixed it." The room erupted. Not with shouting, with reporters typing and cameras zooming. My question isn't whether you'll fix it. You already did. Who decided to redact Les Wexner's name in the first place? That was the moment Bondi made her biggest mistake. Instead of answering, she attacked. She called him a failed politician. She accused him of Trump derangement syndrome. Massie's expression didn't change. I wrote the law you are violating, he said quietly. Answer the question. She never did. Dan Goldman had been waiting with a thick black file on his desk. The kind people bring when they're about to show something never meant for the public. He opened it carefully. Attorney General Bondi, he began. I want to talk about the Epstein documents. He explained that he had reviewed unredacted versions of communications tied to the investigation. The public versions had large sections blacked out, names removed, conversations erased. He pulled out one specific email, a communication between Jeffrey Epstein and Ghislaine Maxwell. Goldman pointed to the redacted sections and asked directly, if there is no lawyer involved in this conversation, how can attorney-client privilege apply? Bondi defended the department's review process. Goldman opened the file again. Another document, again blacked out, again justified as privilege. According to Goldman, some of the hidden references included mentions of Donald Trump. His argument was about transparency. If redactions are applied incorrectly, information that should be public stays buried. The black file sat open on the desk, and one question hung in the air. Who decided what the public was allowed to see? The most chilling exchange came when Lieu questioned FBI Director Kash Patel. The answers you have given today, Lieu told him, display patterns I recognize from hundreds of interrogations. Patel shifted at the witness table. Lieu walked him through a simple question. In major investigations, how do files move through the FBI? Patel explained that significant cases are escalated through leadership and ultimately reach the director's office. Would you classify the Epstein investigation as an important case? Yes, of course. So the Epstein files came to your desk. Patel adjusted his posture. Some materials were summarized for review. Liu's expression didn't change. Summaries. You're telling this committee that the largest trafficking investigation in recent memory was summarized rather than fully reviewed. He asked how many agents had been assigned. Patel estimated around 10. Lieu said nothing more about that number. Then the final question. Will every document, every photograph, every piece of evidence eventually be released to the public? Patel paused. Some materials, he said carefully, may never be appropriate for public release. Liu nodded slowly. He closed his notes. The hearing's most dramatic moment came at the very end. Liu had placed every document on the table, the bank record, the privilege log, the structured payments, and now a forensic accounting report showing the originating account had been closed within 72 hours of being flagged in a suspicious activity report by the FBI's Miami field office. 72 hours? Attorney General Bondi, were you aware of this account before it was closed? Bondi looked toward her attorney. She lifted her water glass and set it back down. On advice of counsel, I invoke my Fifth Amendment right and decline to answer that question on the grounds that it may tend to incriminate me. The chamber erupted. The chairman called for order. Liu leaned back in his chair. For 17 minutes he had spoken calmly, document by document, question by question. And now 4 numbers hung over that hearing room. $847,000, 18 transactions, 72 hours, and a Fifth Amendment invocation from the sitting Attorney General of the United States. Supporters argued invoking the Fifth implies no wrongdoing. Critics said the documents raised serious questions that remained entirely unanswered. 2 years earlier, Bondi had stated publicly that the American people deserved full transparency about where Epstein-related money had moved. During that hearing, those words came back. What happened behind that $847,000 transfer? Who decided to hide Les Wexner's name? What is inside the millions of pages the DOJ has still not released? The hearing ended. The questions did not.